Okay, everyone can hear me clearly, correct?
Yes, Your Honor. Yes.
Okay, we're on the record in the matter of the state of Michigan versus Idris Woods. Counsel, can I have your appearance, please?
Thank you, Your Honor. Good morning, George. Good afternoon, George and APD on behalf of Mr. Woods for purposes of arraignment only this morning.
Always the
Okay.
I don't know what I just did. I apologize. Start video. There we go. Okay. And you are Mr. Idris Marcel Woods, is that correct?
Yes, yes, ma'am.
Okay, Mr. Woods, I do have a felony complaint here that you need to be arraigned on. The allegations are that on or about August 30th, 2025 at the area of, in count 1, Orchard Street in Lansing, and in count 2, 6270 Cooper Road in Lansing, that you allegedly in both counts committed the act of assault with intent to do great bodily harm, less than murder, or by strangulation. Both counts allege that you did make an assault upon an Allison Cottom by strangulation or suffocation in count 1, and in count 2 with the intent to do great bodily harm, less than the crime of murder. And that both of these counts are contrary to MCL 750.84. Count 1 and count 2 are both felonies. The maximum penalty in each count is 10 years in prison and or $5,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed if the assault was committed in a place of confinement. There is a count 3 of domestic violence that alleges that on or about August 30th at 6270 Cooper Road in Lansing, Ingham County, that you did make an assault or assault and battery upon Allison Cottom, an individual with whom you had a child in common, or resident or former resident of your household, or individual with whom you had a dating relationship. There's a second offense, a notice attached to the domestic violence. It says, take notice that the defendant was previously convicted of assaulting or assaulting and battering his or her spouse, former spouse, individual with whom he had a dating relationship, individual with whom he had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating Michigan Compiled Law 750.812 on or about July 19, 2007. And therefore, upon conviction, will be subject to an enhanced sentence under MCL 750.814. That makes count 3's maximum penalty a misdemeanor, 1 year in jail and or $1,000 in fines, and a consecutive sentence again may be imposed if the assault was committed in a place of confinement. There's an habitual offender, 4th offense notice attached to this complaint. It says, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about March 16, 2016, he was convicted of the offense of carrying concealed weapon in violation of Michigan Compiled Law 750.227 in the 30th Circuit Court for Ingham County, State of Michigan, and that on or about December 16th, 2020, he was convicted of the offense of carrying a concealed weapon in violation of MCL 750.227 in the 30th Circuit Court for Ingham County, state of Michigan. And that on or about April 21st, 2021, he was convicted of the offense of felony firearm in violation of MCL 750.227B in the 30th Circuit Court for Ingham County, state of Michigan. And therefore, the defendant is subject to the penalties provided by Michigan Compiled Law 769.12. That makes your maximum penalty that you're facing in this complaint life if the primary offense has a penalty of 5 years or more. Your primary offense does have a maximum penalty of 10 years, so you're facing up to life if convicted. Do you understand the charges and the maximum penalty, sir? That was a question for you, sir, Mr. Woods.
Hey, yes.
Okay, you have the right to be represented by counsel. Mr. Annette is here to represent you for the purpose of your arraignment only. You do have the right to counsel and the right to have representation at all of your court appearances and the right to be represented by an attorney if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the public defender's office represent you at the expense of the public. You understand your right to counsel, correct, sir?
Yes, ma'am.
Okay, you have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, this matter will continue all the way to jury trial. You are being charged with 2 felony counts, and in both those counts, you have the right to take this matter to a preliminary examination before we can move forward to a trial. You have the right to have that preliminary examination within 21 days of today's date, unless you waive the timeline of 21 days or the court finds good cause to go beyond 21 days. At the time of your examination, you have the right to have the prosecutor establish that they have sufficient probable cause that the felonies you're being charged with were committed, and then sufficient probable cause to charge you as the individual who allegedly committed these felonies. Do you have any questions so far?
No, Your Honor.
Okay, you have the right to remain silent again. Anything you say can be used against you. You have the right to take this matter to trial and maintain your silence at trial, and they can't use that against you at your trial. You have the right at your time of jury trial to the presumption that you are innocent until proven guilty, and the prosecution would have to prove each element beyond a reasonable doubt before you are to be found guilty. You have the right to see, hear, or question any witness the prosecutor calls to testify against you. You have the right to subpoena witnesses that will testify on your behalf, or you can waive your silence and testify at your own trial. Do you have any questions about those rights?
No.
You also have the right to be considered for pretrial release from custody. We'll address your bond in just a moment. You're currently scheduled for probable cause conference before Judge Stacia Buchanan. It's going to be on September 12th at 8:30 in the morning. You have a preliminary examination before Judge Buchanan in person at the court September 19th at 8:30. Did you receive your notice to appear?
Yes.
Okay. Is he requesting the public defender to represent him, Mr. Annette?
Yes, Your Honor.
The court's going to enter a plea of not guilty on your behalf. Are you currently on probation or on parole?
I am on parole.
Do you have any other criminal matters pending at this time?
No.
Are you employed?
Yes.
Where?
I work at a bond chest. It's an auto factory.
What's your home address?
3816 Wilson Avenue, Lansing, Michigan, 48906.
And that's not the address of Allison Cottom, correct?
No, it's not.
What's your phone number?
248-416-9983. This is crazy, man.
Mr. Woods, don't make any comments, please.
Your Honor, I just got a question, or I was wondering.
What's your question, sir?
I literally just got out of prison like 2
Oh,
months ago.
Mr. Woods,
That job I got is very important. I do not want to lose my job. I need to get out of here because I got to be back to work on Tuesday.
What's your question, sir?
I'm trying to see, am I going to be able to get a bond or PR bond or something? I need to be at work.
I'm trying to see if you're going to get a PR. Well, I'm not trying to see if you're going to get a PR bond. We don't need to beat around the bush. You're definitely not getting a PR bond because you're on parole, so you're not a candidate for PR bond. But I'm going to see if you're going to get or what your bond's going to be. I'm reviewing your criminal history right now. I have here a bond recommendation from the prosecutor's office. They express a concern about the protection of the public. They said this crime, as alleged, or as charged, involves violence towards another person, and that the defendant, has a history of violent behavior towards this particular individual, and there's a history of threatening and or harassing behavior towards the victim or witnesses, and that there is an intimate partner relationship there. The other factors that they want the court to consider include an escalation of violence or risk-taking over time, acute depression or unpredictable and violent mood swings, and attempt to isolate the victim or prevent the victim from reporting. It should also be noted that in this particular case, it's alleged that the crime, do not interrupt me while I'm talking, okay? It should also be noted that the crime as alleged was committed in the presence of your 14-year-old child who called 911 indicating that her mother was bleeding. The people are requesting $50,000 cash surety bond with GPS tether to include 2,000 feet exclusion zone and victim notification if possible to ensure the safety of both the victim and the community. The allegations include the victim expressing genuine fear and that although, sir, you have only one prior domestic violence conviction, you actually have been charged and arrested 7 times prior to this for domestic assault related charges. Mr. Nid, did you want to make any allocution before the court imposes bond?
Yeah, I would just ask the court to consider lower than the 50,000 recommended. Just so Mr. Idris can ensure that he returns to court maybe like a 10,000, 10%, or 10,000, 10% with a GPS tether. Mr. Woods does want to be released, obviously, to go back to work and take care of his children. He does have 6 children, 6 minor children, taking that into consideration, Your Honor.
Wish I would have had a camera. For real.
Mr. Woods.
This is crazy.
Mr. Woods, you're being allowed.
If you're gonna keep having outbursts, I can just remand you, and then we don't have to do this. I'm trying to review your criminal history. Okay, I've reviewed your criminal history. I understand your concerns, and that you are appear to be emotional about the situation, or upset, I should say, about the situation. The court was in receipt or is in receipt of a affidavit of probable cause, which I reviewed before I signed off to these charges being issued. In addition to factors that led to the charging of both a domestic violence and 2 separate counts of assault with intent to do great bodily harm less than murder or by strangulation. You're being charged with a DV for second offense notice after having at least 7 arrests for domestic violence. And then you have an habitual offender 4th offense notice because of your felony conviction history, which means you are facing life in prison. So these are very serious allegations that you have here. In addition to that, this was a call reported by a minor, allegedly the interactions having taken place in the presence of said minor. And then when the officers allegedly made contact, you had to be taken in to the hospital due to your level of intoxication and lack of responsiveness. It should be noted that even as you're appearing here today, it looks like you still have on the hospital clothing. I believe that there is a concern for the safety of the public and to the victims. I think that the request for a cash surety bond is appropriate. Bond will be set in the amount of $50,000 cash surety with GPS tether. You're not to be within 2,000 feet of wherever the victim is. You're not to have contact with the victim, not directly, not indirectly, not from the jail, not outside the jail, not from your inmate number, not from another inmate number. The prosecutor's office will monitor your calls. Do you understand that?
Yes.
While out on bond, you're not to engage in any assaultive or threatening behavior. You're not to possess a firearm, ammunition, or weapon of any kind. You're not to travel outside the state without prior approval of the court. You must report to pretrial services within 48 hours of your release. GPS tether is being ordered. I'm also going to require that you participate in regular urinalysis testing due to the allegations that your level of intoxication and lack of responsiveness when the officers arrive. There may be a issue the court believes with maybe alcohol or substance. So the court is going to monitor that as well while out on bond. Do you have any questions at this time?
No.
Any additional matters for the record? So I can't hear you, Mr.
Sorry,
Nope.
nothing further. Thank you.
Thank you. You're all set.
I ain't even see it. I ain't see it today.
Who is having a concern in there? On the record in the matter of the state of Michigan versus James Lamar Duncan II. Appearance, please.
Good afternoon, Your Honor. George and Ed, Assistant Public Defender on behalf of Mr. Duncan for purposes of arraignment only this afternoon.
Thank you. And you are James Lamar Duncan II with your hood on in court?
Yes.
Yes.
Thank you. Okay, today was the date set for an arraignment. I do have a felony complaint here. It alleges that on or about August 30th, 2025 at South Martin Luther King at or near William Street, which is located in the city of Lansing, Ingham County, state of Michigan, that you allegedly committed the act in count 1 of police officer assault, resisting, obstructing. And that's also the charge in count 2. As to count 1, it alleges that you committed the assault, batter, wound, resist, obstruct, oppose, or endanger Officer Haven Hyatt. And as to count 2, it's as to Officer Derek Selden, both police officers of the Lansing Police Department, that the defendant knew or had reason to know was performing their duties, and that this was in violation of Michigan Compile Law 750.81D1. Both count 1 and count 2 are felonies. The maximum penalty, 2 years and or $2,000 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement or for another violation arising from the same transaction. There's an habitual offender second offense notice. It says take notice that the defendant was previously convicted of a felony or attempt to commit a felony, and that on or about July 15th, 2015, he was convicted of the offense of carrying concealed weapon in violation of Michigan Compile Law 750.227 in the 30th Circuit Court for Ingham County. Therefore, the defendant is subject to the penalties provided by MCL 769.10 that enhances your penalty to 1 1/2 times the maximum sentence on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the charges read, the maximum penalty, and the habitual offender second offense notice, sir?
Yes.
Okay, you have the right to be represented by counsel. Mr. Annett is only here to represent you because you're being arraigned today. You have the right to have an attorney to represent you at all of your court appearances, and a right to attorney to represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can request to have the public defender's office screen you for representation for free. You understand that, correct?
Yes.
You have the right to remain silent, and anything that you say and anything you put in writing can be used against you. You can plead guilty, plead not guilty, or stand mute. If you stand mute, this matter will continue all the way to a jury trial. You're being charged with 2 felony counts. You have the right to preliminary examination within 21 days unless you waive that 21-day timeline or the court finds good cause to go beyond the 21 days. At the time of the exam, you have the right to require the prosecutor to establish that they have sufficient probable cause that the felonies were committed, and then probable cause sufficient to charge you as the person who committed said felonies. You understand that?
Yep. Yes.
You're scheduled for probable cause conference before Judge Tony Flores, September 11th, 9 o'clock in the morning. You have preliminary examination before Judge Flores in person at the court, September 18th, 9 a.m. Did you receive notice to appear?
Yes.
You have the right to the presumption that you are innocent. So you're innocent until proven guilty. You can require that the prosecutor prove your guilt by taking this matter to jury trial, and they would have to prove each element of the charges being brought against you beyond a reasonable doubt. You can maintain your silence at trial and not have silence be used against you, or you can waive silence and testify. You have the right to present evidence or subpoena witnesses to trial that will testify on your behalf, and the right to see, hear, and question any witness called to testify against you. Do you have any questions about any of those rights?
No.
You have the right to be considered for pretrial release from custody. We'll address your bond in just a moment. Is he requesting a public defender's office?
Yes, Your Honor.
The court will enter a plea of not guilty on your behalf. Are you employed, sir?
Yes,
Where?
employed for a third party to GM.
What's your home address?
3015 Cabot Drive, Lansing, Michigan, 48911.
What's your phone number?
517-574-6606.
Are you on probation or on parole?
Oh,
Do you have any other criminal cases pending?
no.
Counsel, you can address bond.
Thank you, Your Honor. I would ask the court to consider a PR bond at this time. Mr. Duncan has a very limited criminal history from what he reports to me. The charge within itself, it's not clear whether it's assaultive in nature. Your Honor, as the court knows, a simple direct no response could lead to a felony charge of resisting and obstructing. Mr. Duncan has one child and 2 living with him, so he takes care of 2 children, to my understanding. Based on the circumstances, there's no information given that he's a failure to appear. He has issues with failure to appear to court. He assures me that he'll be to court for every hearing. I'd ask for a PR bond at this time, Your Honor.
Okay. I recognize that a limited criminal history is, I guess, relative. Some people might think it's limited, some people may not. I don't consider his history limited. He's got a conviction from 2010, conviction from 2014, conviction from 2015. He was charged in 2024, but it looks like that was dismissed. And then now he has this case. Oh, he's charged in 2024 on another matter. That was also dismissed. But he has this case, and it's being charged as a habitual offender, second offense notice. So it's not very limited. But this is not a matter that the court believes that a personal recognizance bond is not appropriate. So the court will grant the request for personal recognizance, 1,000 personal recognizance. Your conditions are that you must appear to all of your court dates. You are not allowed to travel outside the state without prior approval of the court. You're not allowed to possess or use alcohol or drugs unless you have a valid prescription. You're not to possess a firearm or any other dangerous weapon, and you must report to pretrial services within 48 hours. Okay, sir?
Okay.
Do you have any questions about your bond conditions?
No.
Any additional matters for the record, counsel?
No, Your Honor, thank you.
You're all set, sir. The state of Michigan versus Wendell Darnell Aldridge. Counsel appearance.
Good afternoon, Your Honor. George Ned, Assistant Public Defender. On behalf of Mr. Aldridge, purposes of arraignment only this afternoon.
You are Wendell Darnell Aldrich, sir.
Yes. Yes, ma'am.
Okay, Mr. Aldrich, I do have a felony complaint here where the allegations allege that on or about August 30th, 2025 at East Kalamazoo and Cedar, City of Lansing, Ingham County, State of Michigan, that you allegedly committed the acts, count 1, 2, and 3, all assault with a dangerous weapon, also known as felonious assault, count 1 as to an assault upon a Tiffany Tartamella, count 2, an assault upon an Amber Whitmore, and then count 3, an assault upon a Joshua Phillips. All 3 counts allege that you did make an assault with a dangerous weapon, that being a glass bottle, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, that this is contrary to MCL 750.82. Count 1, 2, and 3 are felonies, each having a maximum penalty of 4 years in prison and or $2,000 in fines. DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. However, there is an habitual offender fourth offense notice. It says, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about October 11, 2020, he was convicted of the offense of controlled substance possession less than 25 grams in violation of MCL 333.74032A5 in the 30th Circuit Court for Ingham County, State of Michigan, and that on or about October 10, 2007, he was convicted of the offense of controlled substance delivery manufacturing less than 50 grams in violation of MCL 333.7401284 in the 30th Circuit Court for Ingham County, State of Michigan, and that on or about April 14th, 2011, he was convicted of the offense of police officer fleeing third degree in violation of MCL 257-60283 in the 30th Circuit Court for Ingham County, State of Michigan, and therefore the penalties, sir, are enhanced. So your penalty is 15 years or less because the primary offense has a penalty under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the counts read in 1 through 3 and the habitual offender notice, which does enhance your maximum penalty?
Yes, ma'am.
You have the right to an attorney. Mr. Annett is representing you today for your arraignment. You have the right to counsel if questioned by law enforcement, and the right to counsel at all of your court appearances. If you can't afford to hire an attorney, you can request for the public defender's office to represent you at the expense of the public. You understand your right to counsel, correct?
Yes, ma'am.
You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue to a jury trial. You have the right to a preliminary examination because you are being charged in counts 1 through 3 with felonies. You have the right to have the preliminary examination within 21 days of today's date unless you waive the 21 days or the court finds good cause to go beyond the 21 days. You're currently scheduled before me to have a probable cause conference, September 12th, 9 o'clock in the morning. You have a preliminary examination before me in person at the court, September 18th, 2025 at 8:30 in the morning. Did you get notice to appear, sir?
Yes, ma'am.
Okay, thank you. Okay. You have the right at the time of your exam to require the prosecutor to establish sufficient probable cause that the felonies alleged were committed, and then probable cause sufficient to charge you as the individual who have committed those felonies. You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You can plead guilty, plead not guilty, or stand mute again. You have the right at the time of trial to maintain your silence, and that cannot be used against you. You can waive silence at trial, and you can take the stand and testify if you'd like. You have the right to subpoena witnesses that will testify on your behalf. You have the right to see, hear, or question any witness that's called to testify against you. And you have the right to require the prosecutor first prove each element of the charges being brought against you beyond a reasonable doubt, and you maintain the presumption of innocence until that is done. Do you understand that, sir?
Yes, ma'am.
Do you have any questions at this time about your rights?
No, ma'am.
Are you currently on probation or on parole?
No, ma'am.
Do you have any other criminal matters pending at this time?
No, ma'am.
Are you employed?
Yes, ma'am. I'm a caretaker for my mom. Excuse me.
What's your home address?
500 South Pine Street, Lansing, Michigan, 48933. Department of 5.
What's your phone number?
The house number 517-253-0119.
What's your cell phone number?
517-883-3567. Your Honor, may I say anything?
Why does everyone say something while I'm trying to review their criminal history? Like every time when it's time to review the criminal history, everyone has something in their spirit that they want to share.
I was just
Mr.
wanting to say, I'd like to join.
What did you want to say, sir?
I was just wanting to, I was just trying to ask you that I have been in front of you before. And
Well, that, okay.
okay, what I'm saying is that I'm not a bad person. And I know I will come back to court and all that because I have came back to your court plenty of times. I have never not came to a court hearing.
What he's referring to is there was a situation he mentioned where he went to the wrong courthouse, and then I think he was sent back, and you gave him some admiration for coming in later on. It was mentioning something about it earlier.
Yes, yes.
To.
And
Okay.
I love your hair.
That's enough, sir.
Okay. I'm glad to hear that you're not a flight risk, sir.
Okay, thank you.
You can address bond counsel. You're muted.
Sorry about that, Your Honor. I would ask the court to consider either a PR bond or a very low cash bond due to Mr. Wendell's very limited income, which is essentially something on. He won't be, even if you had it posted at like $10, he won't be able to post. I understand the seriousness of the allegations, but as the court knows, these are mere allegations. Mr. Wendell needs to take care of his mother, and live, go upon live upon his daily activities with trying to find work. Last, I think he was looking for interview at Paramount Coffee. That was some time ago. That fell through quite some time ago. Other than that, he's just still looking for work, Your Honor, besides taking care of his mother, his elderly mother. He's not a flight risk, and I understand the safety of the community. I'm not sure what the affidavit says, but as the court knows, these are mere allegations, Your Honor. Thank you.
Okay, let's see here. But you told me you were working, sir. I asked you if you're employed. You said yes, and you said you were your caretaker. You don't get paid for that, sir?
I get paid for it, but I split it with my sister, my older sister.
Okay, so you share the responsibility. You're not
Yeah,
full-time,
yeah.
not full-time employment, but you're looking for employment is what you're saying, is what your attorney is saying?
Yes. Yes, ma'am. I'm every day.
And you live at this 500 South Pennsylvania Avenue?
Yes, ma'am.
Is that
Apartment five.
isn't that a senior residence?
Yes, ma'am.
So you're not allowed to live there then?
No, I can live there if I take care of my mother, and you got to be a family member.
And you're on the lease there, is what you're saying?
Well, they never said that to me. Every time I come there, the office, they let me in.
That was not my question. And see how the answer shifted. If I called the leasing office and asked if you're named on the lease as a resident there, they're gonna tell me yes.
Yes, they should. I've been there for about like 5 years, close to 5 years. The last time I came to court, that's the same address I gave it to you. And that's where I was at.
I know you would love for me to have remembered everything you told me last time. I don't even remember you failing to appear before. I actually don't even remember. I remember your name. I don't remember the case that was last before me, but I'm assuming that because I just reviewed your prior criminal history, it was the case from last year that was ultimately dismissed. Is that accurate, sir? Okay.
Yes, sir.
And then you somehow the system has now reassigned your new case to me as well. If you don't live at, if I find out that you don't reside at 500 South Pennsylvania and that you're maybe residing somewhere in a tent, it's going to be problematic for you. You understand that?
Yes, ma'am.
Okay.
Yes, ma'am.
Okay. And so, because I gave you an opportunity to be upright and forthcoming with me about where you reside. And so at this point, there is a bond recommendation that it must be placed on the record from the office of the prosecutor on this case. They said that they have a concern for the protection of the public under MCL 765.6. It says that this crime charges involve violence towards other people. There's a history, it says, of violent or threatening or harassing behavior towards the victim or witnesses. It says other factors that they believe are associated with the risk of lethality is an escalation of violence or risk taking over time, acute depression, or unpredictable violent mood swings in attempt to isolate the victim or to prevent them from reporting. The people are requesting $15,000 cash surety bond with GPS tether, a no contact order as to the 3 victims, alleged victims, Amber Whitmore, Tiffany Tartamella, and Joshua Phillips, as well as an order not to use any alcohol or any controlled substances. It should be notified that you understand that you're being alleged to have committed felonious assault on 3 different people with a bottle, sir. And the allegations provide that at the time, the underlying situation involved one of these individuals trying to help someone who was padlocked inside a tent that you own. And so
Yeah.
that is I'm not asking you to speak because anything you say can be used against you. I'm trying to get you to understand the factors and the information that the court has to consider when setting a bond. I am going to, when I review your criminal history, I do see other assaultive charges. There's a large amount of drug-related charges and convictions. I don't see a lot of, I think only one other violent conviction, but that was, I believe, as to an officer. And so I don't see a lot of other assaultive actions. There were 2 charges of domestic violence that were dismissed, and that was back in the 90s. I will grant at this time a personal recognizance bond, but with GPS tether. And you are to be residing at 500 South Pine Street, apartment 5.
Yes,
Do you
ma'am.
understand that?
Yes, ma'am. Where do I get the teller at?
You hang tight. Don't you worry. You won't be released from jail without getting a tether. So you don't even have to figure out where you get it from. It's not like you're going to leave and you got to go figure out where to get it. The jail is going to take you right. You're not getting out without a tether on you. So you don't have to worry about that. Okay.
Okay.
The alleged location of this incident is East Kalamazoo at or near Cedar under the bridge. You're not to be within 2,000 feet of that. Do you understand that?
Yes, ma'am.
You're not to have contact directly or indirectly with the alleged victims, Amber Whitmore, Tiffany Tartamello, or Joshua Phillips. You can't
Yes, ma'am.
send word to anyone else, no communication of any kind, text message, written or verbal. Do you understand that?
Yes, ma'am.
If you see them, you need to go the opposite direction because you're not to be anywhere within 2,000 feet of wherever they are. Do you have any questions about that?
No, ma'am.
You are not to possess any alcohol or drugs. You're not to have a firearm or ammunition or any dangerous weapon or weapon of any kind. That would include broken glass bottles. You understand that?
Yes, ma'am.
Okay. And you're not to travel outside the state without prior approval of the court, and you need to report to pretrial services within 48 hours of your release from custody. Do you have any questions at this time?
No, ma'am. Thank you.
Bond is 1,000 personal recognizance with GPS tether. Any additional matters for the record, counsel?
No, Your Honor, thank you.
Thank you. People of the state of Michigan versus Aisha Mohammed El-Wadi. Appearance, please.
Good afternoon, Your Honor. George and Ed, Assistant Public Defender on Miss Aisha, on behalf of Miss Aisha, for purposes of arraignment only this afternoon.
And you are Miss Aisha El-Wadi, is that correct?
Yes, Your Honor.
Okay, I do have a felony complaint here. The alleged actions here in count 1 are that on or about August 30th, 2025 at 6258 Beachfield, City of Lansing, Ingham County, State of Michigan, you allegedly committed the act of assault with a dangerous weapon, that being a felonious assault. The allegations are that you made an assault upon a patron El-Wadi with a dangerous weapon, that being a knife, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. And this was in violation of Michigan Compiled Law 750.82. That's a felony. The maximum penalty is 4 years in prison and or $2,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Count 2 is a misdemeanor assault and battery, alleging that at the same date and location you made an assault or assault and battery upon a patron El-Wadi, contrary to Michigan Compiled Law 750.811. That's a misdemeanor. The maximum penalty in count 2 is 93 days in jail or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You understand the charges that was read in the maximum penalty?
Yes, Your Honor, I do.
Okay. You have the right to be represented by an attorney. Mr. Annette is going to represent you to be arraigned today. You have the right to counsel if questioned by law enforcement, and the right to counsel if you're going to appear in court for any of the criminal prosecution. If you can't afford to hire an attorney, you can make requests to have the public defender's office represent you at the expense of the public. You understand that right to counsel, ma'am?
Yes, Your Honor.
You have the right to plead guilty. You can plead not guilty, or you can stand mute. If you stand mute, the matter will continue to jury trial. You are being charged in count 1 with a felony, so that entitles you to a preliminary examination. You're entitled to have that within 21 days unless you waive the timeline or the court finds good cause to go beyond the 21-day timeline. You're currently scheduled for probable cause conference before Judge Cynthia Ward on September 11th at 8 o'clock in the morning. You have a preliminary examination before Judge Ward in person September 18th at 8:30. Did you receive your notice to appear, ma'am?
I did. Yes, Your Honor.
Very good. Okay, let's see. You have the right, at the time of your examination, to have the prosecution establish first that they have sufficient probable cause that a felony was committed, and then probable cause sufficient to charge you as the individual who committed the felony. If this matter continues beyond a preliminary examination, you have the right to a trial. You are innocent until proven guilty, and you have the right to carry that presumption of innocence until the prosecutor can prove each element of the charges being brought against you beyond a reasonable doubt. You understand those rights?
Yes, ma'am, I do.
At the time of jury trial, you have the right to remain silent and not have silence be used against you, or you can waive your silence and take the stand and testify. You have the right to subpoena your witnesses to testify on your behalf or to present evidence that will show a defense to the charge being brought against you. You have the right also to see, hear, or question in court any witness called to testify against you. Do you understand those rights?
Yes, Your Honor.
Do you have any questions about any of your rights?
I do not, Your Honor.
Okay. Let's see. Are you currently on probation or on parole?
No, I have no previous anything.
Okay, very good. Is she requesting the public defender to represent her counsel?
Yes, Your Honor.
The court is entering a not guilty plea on your behalf. Are you employed, ma'am?
At a lot of different places. I just got hired for a federal 911 dispatcher job. I'm just waiting for the federal background check to come back. That will be in Battle Creek, and I do Amazon Flex and Uber because I'm my mom's full-time caregiver, and Mr. Bertrand Alwadi, my brother, as well. I am his caretaker because he has schizophrenia and bipolar 2 disorder, and my mom has mobility issues. So I moved back to Michigan to take care of them 2 years ago now.
Okay, so you'll say you also do Amazon Flex, you said?
Yeah, and Uber and Lyft. And I'll be starting the 911 job, dispatcher job, once the actual federal background check comes back, which could take a few more weeks.
So she is correct, counsel. She does not have anything else on her criminal history. The concern is the address, and obviously that the alleged victim lives at that address. That's correct.
Yes, Your Honor, we talked about that. She does have an address to provide you. A different one.
Okay.
That she
Does your mother live at the 6258 Beachfield?
She does. All three of us live there. It's actually our condo. We own it.
Okay, so I'm not sure how you're gonna work this out, because if you were your mother's caretaker, you're not gonna be allowed to be at that address if your brother resides there. So something, I don't know, something's gonna have to transpire that you need to figure out. I'm going to grant you a personal recognizance bond. You don't have any prior criminal history. And so a bond will be set in the amount of 1,000 personal recognizance. Again, you're not to be at that address. I recognize that you live there, so you're gonna have to, I gotta give you an opportunity to send a third person, or if for whatever reason law enforcement is so inclined to oblige you to go and get some things, your personal belongings. Where are you going to be residing while this matter is pending?
I'll be staying with my best friend, Mercedes Cantu, at her house, 4240 Glenburn. I think it's Glenburn Avenue or Street. It's off of Waverly and Jolly. So 4240 Glenburn, GLENBURNE.
Very good. What's your phone number, ma'am?
480-494-9731.
Okay, so I'm assuming maybe your best friend will be the person that will go and retrieve personal items on your behalf.
I'll probably have my mother bring them to me.
Okay, sounds good. Okay, let's see. Bond is 1,000 personal recognizance. There's a no contact order between you and Bertrand Alwadi, so you can't have contact with him directly or indirectly. You can't send any communication through a third party to him. Do you understand that?
Yes, I do, Your Honor.
You're not to be within 2,000 feet of wherever he is.
Okay.
Okay, let's see. Also, while out on bond, you have the following conditions. You're not to travel outside the state unless you first get approval from the court. You're not to possess a firearm, ammunition, or weapon of any kind. You're not to use drugs or alcohol unless you have some prescription. And then you need to report to pretrial services within 48 hours of your release. You'll get the information on how to report from the jail, okay?
Okay, thank you so much.
Problem, do you have any questions at this time?
I do not, Your Honor.
Any additional matters for the record, counsel?
No, Your Honor, thank you.
You're all set.
Thank you.
You're welcome. Let's see. This is the state of Michigan versus Tyrell Michael Emerson. Appearance, please.
Thank you, Anna. George Annette, Assistant Public Defender, on behalf of Mr. Tyrell Emerson for purposes of arraignment only this afternoon.
Good afternoon.
Good afternoon. Mr. Emerson, I have a felony complaint that charges you in count 1 with weapons carrying concealed. The allegations are that on or about August 31st, 2025 at 2206 Rysdale Avenue, Lansing, Michigan, that you did carry a dangerous weapon, that being a pistol, concealed or on or about your person. This is a felony, maximum penalty 5 years or $2,500 in fines, and a mandatory forfeiture of the weapon or device is required under the law. You understand the charge and the maximum penalty?
Yes.
You have the right to counsel. Mr. Annette is representing you for your arraignment. You have the right to have an attorney represent you at all of your court dates, and the right to an attorney if questioned by law enforcement. If you can't afford an attorney, you can let the public defender do a intake to see if they can represent you for free. Do you understand that, sir?
Yes, ma'am.
Okay. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, this matter is going to go all the way to a jury trial. You are being charged with a felony, sir, so you have the right to have a preliminary examination within 21 days of today's date, unless you waive the 21-day timeline or the court finds good cause to go beyond the 21 days, okay?
Okay.
Okay. You are scheduled for a probable cause conference. It's before Judge Stacia Buchanan. It's going to be on September 12th at 8:30. You have a preliminary examination before Buchanan in person at the court September 19th at 8:30. Did you get your notice to appear?
Can I look at the paper, please?
I'm sorry?
I look at my papers, but I got my court date.
Yes, absolutely.
So I got one for the 12th and the 19th. That's it. That says on the paper.
That's exactly the dates I just gave you. So your probable cause conference is September 12th at 8:30. Your preliminary examination is going to be 9/19 at 8:30, but you have to appear in person for the preliminary examination. Your probable cause conference, you have the option of appearing in person or via Zoom, okay?
Okay.
Okay. At the time of your preliminary examination, you have the right to require the prosecutor establish sufficient probable cause that a felony was committed, and then probable cause sufficient to charge you as the person who committed the alleged felony. Do you understand that?
Yes.
Okay. You have the right to take this matter to jury trial. You have the right to the presumption of innocence at trial, and to maintain that presumption until the prosecutor can prove each element of the charge being brought against you beyond a reasonable doubt. You have the right to question or cross-examine in court any witness called to testify against you, the right to subpoena witnesses to testify on your behalf, the right to remain silent at trial, not have silence be used against you, or you can waive your silence and testify at your trial. Do you have any questions about any of those rights?
No, ma'am.
Are you currently on probation or on parole?
No, I do not have a criminal history.
Are you employed?
Yes, I am.
Where, sir?
I work at Tentacle Automotive on Grand River. The exact address is 44247, I think Grand River, but that's the exact street.
Okay. What's your address?
2206 Rysdale.
And your phone number?
Say that again.
What is your phone number?
517-377-7992.
Counsel, you can address bond.
Thank you, Your Honor. I'm asking the court to consider PR bond in this matter based on Mr. Anderson's report to me and the court of his no criminal history. There's no flight risk. He's employed. He's been working at a job for almost a year now. He has one minor child that lives with him that he takes care of. He's not going anywhere, Your Honor. He'll show up to court and take care of things accordingly.
I don't see any adult convictions or pending matters. Bond will be set in the amount of 1,000 personal recognizance. While out on bond, you're not to possess a firearm, ammunition, or weapon of any kind. Do you understand that?
Kind of. Like, I just don't understand like the type of bond because I've never been like arrested. So.
A personal recognizance means you don't have to pay anything.
Okay.
Okay, did you have any questions about the first condition that I just stated to you?
Can you repeat that, ma'am, so I can just make sure, please?
Yes, I told you you're not to possess a firearm, ammunition, or weapon of any kind.
Yes, ma'am, I understand.
Okay, you are not to travel outside the state without prior approval of the court. You're not to use drugs or alcohol without a valid prescription. You must report to pretrial services within 48 hours of your release. And you must come to all of your court dates. You understand that?
Yes, about the 48-hour one, can I get like a phone number to that? Or is
They'll
it on
give
the
it to you
paper?
they'll give it to you in the jail.
Oh, okay.
No problem. Do you have any other questions?
No, ma'am, besides thank you.
Yes, I guess you're welcome. I didn't do anything. You didn't have any other criminal history. This is not an assaultive crime. And you asked reasonable questions. So long as you're clear, make sure you come to all your court dates and you'll see Judge Buchanan on the 12th. Any additional matters for the record, counsel?
No, Your Honor, thank you.
You have a question, sir?
So about the Zoom meeting, like I'll set that up on my phone, or will I like have to come to the courthouse?
You have the option of coming in person for your September 12th. The preliminary examination on the 19th, you must appear in person. You would have to download Zoom. You need to have, and the instructions on how to dial in should be on the piece of paper. I believe Buchanan's Zoom paperwork should be yellow. Did you get a yellow piece of paper?
Yes, ma'am.
Okay, you need to make sure when you log in for Zoom court that you're ready for court. So you can't be doing anything like driving, which is against the law while you're in court. You can't be eating, drinking, working. You need to be in an appropriate location and position and appropriately dressed for a court proceeding, even if you appear via Zoom. Do you understand that?
Yes, ma'am.
So yes, you will log in. And you should probably test it beforehand, because if you wait until the day of and you can't figure out how to log in, you might end up with a bench warrant. So you should test how to use Zoom prior to your court date, okay?
Yes, ma'am.
Okay. You're all set.
Thank you. Thanks, George.
You're welcome.
Yes, sir.
Okay, let's see. This is the state of Michigan versus Emma Louise Hatz. Counsel appearance, please.
Thank you, Your Honor. George Annette, Assistant Public Defender on behalf of Emma Hatz, purposes of arraignment only.
You're Emma Louise Hatz.
Yes, Your Honor.
Okay, Ms. Hatz, I have a felony complaint here. The allegations are that on or about August 30th, 2025, at South Hosmer and Bement Street, City of Lansing, Ingham County, that you did allegedly commit the act in count 1 of controlled substance delivery manufacture of methamphetamine. The allegations are that you did possess with the intent to deliver the controlled substance of methamphetamine contrary to MCL 333.74012BI. That's a felony with the maximum penalty of 20 years in prison and or $25,000 in fines. Do you understand the charge and the maximum penalty, ma'am? I can't hear your response.
Yes, Your Honor.
Okay, you have the right to counsel. Mr. Annette is representing you to be arraigned, but you have the right to have an attorney represent you at all of your future court dates and if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request for the public defender's office to represent you at the expense of the public. You understand that?
Yes, Your Honor.
Okay, you have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, this matter is going to go to trial. You have the right prior to trial to a preliminary examination because you are being charged with a felony. You have the right to have a preliminary examination within 21 days of today's date unless you waive the 21 days or the court finds good cause to go beyond the 21-day timeline. You're currently scheduled before a probable cause conference before me, Judge Kristen Simmons. It's going to be on September 12th at 9 o'clock in the morning. You have a preliminary examination before me, September 18th at 8:30. You must appear in person. Do you understand that?
Yes, Your Honor.
Did you get your notice to appear as well as instructions on how to appear virtually?
Yes, Your Honor.
You have the right again to plead guilty, plead not guilty, or stand mute. You have the right to remain silent. Anything that you say can be used against you. You have the right to a jury trial and the presumption of innocence until proven guilty by having the prosecutor prove each element of the charge being brought against you beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You have the right to question or cross-examine any witness called to testify against you, the right to subpoena witnesses to testify on your behalf, and the right to submit witnesses or evidence to show a defense to the charge being brought against you. Do you have any questions about those rights?
No, Your Honor.
Okay. Are you currently on probation or on parole?
No, Your Honor.
Do you have any other criminal matters pending?
I believe.
I can't hear you. Hold your head up so I can hear you.
And the retail fraud.
You have a retail fraud pending?
She should have a failure to appear, Your Honor, on that. I represent her on that. She failed to appear last, I think, a week or two ago.
For a retail fraud in this court?
Yes.
What else do you got pending, ma'am?
I had a drug charge.
A drug charge pending?
Yeah. But I've been going to court every time for that. The only reason I missed court this last time was I had an issue with my boyfriend leaving me out of the city. But I've been going to court every other time.
Do you have any other criminal matters pending?
No, Your Honor.
Are you employed?
Yes, Your Honor.
Where?
Don't you Gary's Home Renovations?
Excuse me? Say that again?
Gary's Home Renovations.
Okay, what do you do there?
We just fix up houses.
You do what to the houses?
We fix them up. I work
I
on,
would-
I paint them. I paint them. I put in windows.
Okay. Are you paid, you're paid with a pay stub or you're paid under the table?
I'm paid under the table.
What's your home address?
704 Hayford,
North or south?
South.
And your phone number?
517-666-6236.
You can address bond counsel.
Thank you, Your Honor. I'd ask the court to consider a PR bond, if not a low cash surety bond. Ms. Hass has very limited income. Me and Emma have had very good communication all the way up until jury trial where her phone got shut off. Her number has changed. I've noticed that, and she did inform me that she got left in, I believe, Grand Rapids by her boyfriend. All a reasonable reason why she didn't show up to court, at least for the retail fraud. You shouldn't have any issues, Emma Hats. I've had probably one of the only clients I've had very good communication with up until her failure to appear. Every time I called her, she always answered. Every time I told her to call her other attorney, she always answered. That's my previous experience with Ms. Hats. In regards to the charge, I do not believe, based on our current conversation, that the charge fits what Ms. Hats informed me. So she'll be fighting this throughout the court process. She does. She was expected to do a probation term in the pending possession charge, I believe, is what she informed me. So I'm hoping that this all gets resolved in the circuit court filing. I asked the court to consider a PR bond or with a GPS tether or a very low cash surety bond to ensure her return.
Thank you. She's not a candidate for a PR bond. She's got a current matter pending, or two current matters pending, and one, I believe, is you said is in a bench warrant status. Yeah, I have this. I have the file right here. So I have here. This must be Judge Flores if you're on it, Mr. Annette.
Yes.
State of Michigan versus Emma Hats 25-00258. This is the retail fraud second that you failed to appear on. It looks like you had more than one failure to appear on this matter. Failed to appear February 20th, 2025. Failed to appear, it looks like.
I didn't receive notice for it in the beginning. I wasn't even aware of it.
Oh, okay. But then you failed to appear June 24th, 2025. You did receive notice then. Let's see here. Judge Flores ordered her remanded on that file. She'll be remanded. Why did you miss court on the 26th?
My boyfriend and I got into a huge fight. He broke my phone. He fucking he left me in Grand Rapids.
Okay, you'll be remanded to see Judge Flores on that file. I think that was supposed to be set. That was supposed to be a jury trial that he failed to appear on. So that will have to be reset. And then as it relates to the felony that I just arranged you on, I do have a bond recommendation here. The people state that there is a issue with the protection of the public because you are either on parole, probation, or have other pending matters. We are aware of at least two pending matters, one being a felony before the circuit court at this time. That there's a record for non-appearance at court proceedings or flight to avoid prosecution. It should be also stated that the allegations, even in the affidavit of probable cause today, was that the defendant gave a false name to avoid detection by law enforcement, and that law enforcement recognized the person because the last name used was a last name that was allegedly previously used by this defendant. There's also, it says, people are requesting $40,000 cash surety with GPS tether to minimize risk of flight and to ensure appearances at court proceedings. Defendant is in danger to herself and continues to use or possess large amounts of illegal narcotics. Additionally, the defendant is on felony bond out of the 30th Circuit Court before Judge Wanda Stokes, and it lists two separate files, not one, and both being controlled substance cases. So she has two use of controlled substance cases out for Judge Stokes. So she's on bond for 3 files already at this time, and this will be the 4th one. And the allegations, again, in this complaint is that large amounts of illegal substances were found on her person, which would explain to the court why it was charged the way it was charged versus why it would have been charged as a use. Nonetheless, I do believe, even as she appears before the court today, that she is in danger to herself, and her life and her own health is at grave risk, and she needs to get some help. What the court is going to do, she's already being remanded on that file. This file, the court's going to impose a bond of $25,000 cash surety. There will be GPS tether, and she will be ordered to participate in urinalysis testing and treatment during the pendency of this case. She's not to possess any drugs or any alcohol. She's not to travel outside the state without prior approval of the court. She's not to possess a firearm, ammunition, or weapon of any kind. She must appear at all of her court dates. Do you have any questions at this time, ma'am? I can't hear you.
Oh, Your Honor.
Okay, again, you're going to be participating in substance abuse testing and monitoring program while out on bond. Lastly, you must report to pretrial services within 48 hours of your release from custody if bond is posted. Any additional matters for the record, counsel?
No, Your Honor, thank you.
Thank you. You're all set. That's all I have.
Have a good day.
Same to you.
Thank you.